All right, good morning and welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's docket. Before I do so, I appreciate you being here this morning. Sorry for any inconvenience. I would much rather be in the courthouse with a bigger courtroom and more space for everyone. So I'm sorry for the cramped room that we have, but we're going to make the most of it. I'm going to call your name. If you hear your name, so please take president or here, raise your hand. So I can write you down. If I don't hear your name, if I don't see your hand, I may mark you down as not being present. Would not be good for you or your bond. Okay. Marvin Anderson. Waiver of arraignment filed. Pretrial set October 25th. Carroll Bryce. I'm sorry, Bryce Carroll. Bryce Carroll. Thank you, Mr. Carroll. Randy Dobbins. Sanctions court hearing, Randy Lee Dobbins. Juan Gonzalez. Jesus Gutierrez. Here. Hey, say your name. I might not be able to see you. Neil Jones. Neil Austin Jones. I'm sorry, Neil Justin Jones. Neil Jones. Garrett Joslin. Here. Joslin here. Okay, thank you, sir. Daniel Ryan Payne, verified in custody in Tarrant County Jail. We'll recall that case. Melissa Schoonover. Jerica Simpson. Jerica Dion Simpson. Mr. Tapper is here. Alejandra Mota. Here. Council's present. Thank you. Michael De La Rosa. Here. Thanks, sir. Ashley Smith. Ashley Lene Smith. Mr. Green here.
Mr. Green is sworn to judge.
John Christopher Goins. Tyler McInnes. The waiver of arraignment has been e-filed and approved. Pretrial set November 10th. Audrey Andrews, waiver of arraignment filed, approved, pretrial set October 10th. Charles Bennett. Jimmy Booker. Jimmy Saul Booker. Savannah Cooksey. Yeah. Kenneth Brunterhouse. Yeah. Jeremy Hester. Right. Noe Lamone. I'm not saying your last name correctly. Stephen Myatt. Here. Is that a plea today, Mr. Schmidt? I believe so. Jennifer Rollins. Here. Dugan Toms. Dugan Lee Toms.
Judge, you should be honest with us, folks. Is right this morning.
Nicholas Doverly,
Here.
Gregory Beaver,
Here.
Leland Cashion,
Here.
Jan Espino,
Here.
Carlos Hernandez, Billy Jennings,
Here.
Mr. White, is that a plea today?
We're going on a PTI today.
Okay, thank you. Christopher McBee,
Here.
Chester Perry,
Here.
Russell Hoovy, waiver of arraignment filed, approved, pre-trial set, November 8th. Joseph Rushing,
Here.
Danny Smith,
Recognize.
thanks, sir. Dakota White, Monty Austin,
Present.
Terry DeWitt,
Here.
Cashion and Jernigan,
Here.
is it Keon?
Yes, sir.
All right, sorry about that. Santana Martinez.
Yeah.
Thank you. Shaquille Rogers,
Here.
Zachary Wooten,
Here.
Daniel Worley.
Here.
All right, is there anyone who's present in the courtroom and I've not called your name?
Your Honor, Jernigan Simpson is not here.
Everyone else? Okay. Council, do we have anyone that is ready, agreed? Not everybody at once, okay? Let's keep our composure.
Your Honor, I believe we're gonna do a PTI today on my client, that she needs to be drug tested as a condition.
Okay. All right, if you'll go ahead and we'll speak with Officer Mature here, we can get that set up. I'll tell you what, I'm gonna go ahead, I'm gonna direct a few of you to submit to a drug test this morning. So when I call your name, I want you to go out in the hallway and Officer Mature will come out there and get you when she is ready. I need the following people. So that's Miss Mota, correct?
Yeah.
Okay. Ms. Cooksey, you can go out in the hallway, wait for Officer Mature. Mr. McBee, Christopher McBee. All right, that's it. Yes. Mr. Wilder. Okay.
She's out in the hall.
Oh, that's fine, that's fine. Just want to let them know that they're ready. All right, we'll take up some other matters here.
Years were we have to. I didn't know it's in there. Different pages on
All right, Mr. Bryce, I'm sorry, Mr. Carroll, Bryce Carroll, if you'll come up, please. All right, Mr. Carroll, this is a sanctions court hearing. And it appears, let's see, I have some notes here. It says that the probation department doesn't believe that you're motivated to complete your conditions of probation. That you've not paid anything to probation, you haven't paid anything on your court fees. Ellis County is indicating to me that they have to keep calling you to give you the report. They had to keep calling you to give you the report for June on the last day of the month. What's going on? You understand what you're possibly facing? You're on a second degree deferred for possession of controlled substance. That's 2 to 20. You understand what you're facing?
Yes, sir.
Okay, so tell me what's the issue with your lack of motivation?
I made a payment yesterday. I guess it has an update in the system because it's still showing a total of $765. You know, I've been searching for a job. I just started a job last week, so when I lost my car, it got repoed. I was behind on car payments, trying to keep up with that. But I'm trying. Like I said, I just started a new job in Freeland at this warehouse, so payments should be catching up within the next month or so.
You know, probation is more than just about paying your fines. You gotta do your community service, you gotta report, you gotta drug test, you gotta do all those things. You understand that, right? If you don't do those things, they're gonna file a motion to revoke, convict you. If you convicted felon, you'll be looking at 2 to 20 in prison. You don't want to be there, right?
No, so,
You have family?
yeah,
Does your family want you to be there?
no, so,
Okay, so this is your path to stay out of prisons. These are the things that you have to do along that path, all right? So this is what I'm gonna do. I want you to go outside in the hallway and I'm gonna have you drug tested and you're gonna come back in. And if you're clean today, we'll talk about some things that we do to get you back on track. All right, okay, so go out there and have a seat and I'll call you back in when you're done. Mr. Gutierrez. Jesus Gutierrez.
Gutierrez?
All right, you're Jesus Gutierrez?
Yes, sir.
All right, Mr. Gutierrez. This is a sanctions court hearing. I have a report from the probation department that says that you admitted to drinking alcohol on June 19th, 2021. Is that correct? Yes. The 21 or 22? I have no idea, honestly. Either way, you understand that you violated this addition to community supervision. You understand that, right? In a way, yes. In a way, is there any way that you can drink alcohol and it not be a violation? Okay, well, I'm gonna tell you that there is not. All right, not if you're consuming alcohol for purposes of consuming alcohol. It's not testing positive because you're taking a cough medicine or something like that contains some kind of alcohol. So, Mr. Gutierrez, you have a choice today. Your choice is I can sanction you for your behavior and we can keep you on probation, or you can tell me, Judge, I don't want to do that, and I'll just report that to the probation department, and they can decide along with the state on what they want to do with you, follow motion to revoke or something along those lines. The sanction that I would have for you is the same sanction that I give for everyone with this type of violation, is that you'd be sanctioned for 3 days in jail for your violation. I would let you, do you have a job? No, I'm not currently. Okay. So what I'll do is I'll let you pick the 3 days that you want to go. Okay, all right. You want me to go ahead and. So what I'm gonna do is I'm gonna write this up. You're gonna meet with the probation department. You can tell them what days that you want to do that. We'll put that in order. I'm gonna sign and give it to you. You're gonna show up on that date with your ID to the jail. You're gonna serve you 3 days. Okay. And then when you get out, you're gonna meet with the probation officer. You're gonna make sure that you're on the straight and narrow. Okay, yes, sir. Okay. You want him out in the hallway? All right, Mr. Gutierrez will have a seat in the hallway, and one of the members of the probation department will be introduced. Randy Dobbins. Randy Dobbins. All these probably have something.
Randy Dobbins. Randy Dobbins.
Here. Oh, there he is. Who's that son? You, Mr. Dobbins? No. Well, I didn't have him check the office here, so maybe he's not here. You didn't have him, you did- okay. So. All right, Juan Gonzalez. Mr. Gonzalez, are you still filling out your paperwork? Okay, then just keep on filling that out. Neil Jones. Neil Justin Jones, still not here. Okay. Mr. Joslin. Gary Joslin. All right. Do you have an attorney, Mr. Johnson? Is it Mr. Schmidt? Mr. Schmidt, you represent Mr. Johnson? I do. Okay. I don't know. And it's unlawful possession of firearm by felon?
That's correct.
Do you need time? I didn't know. I was just calling those out. I didn't have one.
No, we'll talk, but I've got a whole bunch, so we can just do all of them at the same time.
Yeah, so you're gonna have.
Yeah.
Just have a seat, Mr. Johnson, I'll right back to that. For whatever reason, you need to not pour on this topic. So Melissa Shun over here. Right here. For whatever reason, Richard knows it for
Randy Dobbins is on with.
Yep. So we'll do that. Jeff, are you ready?
Your Honor, still waiting.
Do it.
Yes.
Charisma, you're ready to announce that it's your turn.
Logan, you ready?
Yes, I just. Go ahead and slip. May I approach?
You may. Mr. De Rosa. CR 2215, CR 2264. Mr. De La Rosa is set for pre-trial today. Are there any contested pre-trial motions?
Not at this time, Your Honor. Real quick, there are 2 or 3 zeros before 15 and 22.
CR 15, and then, yeah, CR 2214, CR 2264.
64. Okay. Your Honor, the assigned prosecutor is out today. I had sent him an email to try to make some progress. I didn't hear back. I think he's out for training. I'd like to request one more pretrial before setting this for docket call announcement, so I can have a chance to communicate with Mr. Woodwhite about this case before we start setting this on the trial docket.
Is it an issue of discovery or?
It's not a discovery issue. It's just, I mean, there is one item that I've requested that I don't anticipate being an issue. Basically the offense report from his my client's original conviction. But other than that, no, I was really discussing more sort of plea negotiations, punishment range issues, because I think that there's some confusion between us about what my client's punishment range is at trial.
So if there's no pre-trial motion, what I'll do is I'll set the docket call, and that'll give you a chance to speak with Mr. Woodwhite from now. And then he would be put on the jury trial docket after.
Okay.
So let's look at, you got your calendar.
Yes.
That's either October 13th or October 25th.
What is there? Are there any other dates available? I have some potential conflicts on those dates. If there's another option, I'd like to look at it, but I might be able to move things around.
That October 11th.
Hold on, let's do it. I'll try. Let's do. I think the 13th should work.
October 13th.
Yes, that'll be the best.
All right, court sets Mr. De La Rosa for docket call on October 13th. That'll be at 9 a.m. I believe that should be back in the courthouse, the county court, downstairs.
What happened to
Or they're just old notice of settings, or they're not new, so.
what happened to the building? Was it flooding?
Flooded.
What do I check off docket call announcement?
You can write it. Those are the old reset form, so you just.
Okay.
Just make it work, as long as we know date and time he's coming back, these times go back.
Okay.
All right, Mr. Davis, so we'll see you back on October 13th. You'll get a copy, okay? Thank you. Sure. All right, court's going to call cause number CR 2372, State Resident Hunter Tapper. Mr. Tapper, we had you set to hear about hiring an attorney. Any progress on that?
I have a meeting with Tyler. And I would be able to hire him.
What time were you supposed to meet? 4 o'clock again? All right, Mr. Tapper, what I'm gonna do is I'm gonna reset your case until October 11th. To give you more time to hire your attorney. Obviously, you've taken an effective today on the outstanding one. Okay, so whenever you post bond, if you don't post bond, and maybe Mr. Adam you to the jail. Okay, so I'm gonna set you for October 11th. That'll be at 9 a.m. All right, Mr. Tapper, I'm gonna have you sign right here, and we'll make a copy of that, resetting the case to October 11th. Yes. I see. It's like, do you know what's with Mr. Schmidt's client here, Mr. Front House?
Yes, Your Honor, we are working on paperwork right now for judgment. He's been arrested for some charges that we don't have cases in our office yet. So we are making sure those are also included in the judgment, and then we would be ready.
Please.
Yes.
Okay. Mr. Green, are you ready, sir?
I am just apologize for being late, in this paper hand, that, I appreciate it for sending something that I didn't bother to read until I got to the courthouse, saw the page to the door.
Okay, we knew it was gonna happen. We weren't betting on you though. Okay. You've upset a lot of people.
I remember getting it, I just don't, I didn't put it on my calendar.
Is Ms. Smith in here?
She just stepped out, but it's.
Yeah, we'll call her. Court's gonna call CR 21-341, 2021-434, State versus Ashley Lanace. Come on up, Ms. Smith. Mr. Green, there you go. Ms. Smith is set for docket call today in both cases.
Judge, we have an agreement, proposed agreement worked out. I would like to ask court to set it for plea. We need to file a petition in Judge Kirkpatrick's court to get an occupational driver's license resolution. So a result of a 90-day driver's license suspension from this.
How long do you need for that?
I don't know how long it would take to get from Judge Kirkpatrick. I wouldn't think it would take very long, but maybe just a month.
Any objections to the state?
No, Your Honor.
All right, today being the 20th. How about October 25th?
I think that date's good, Judge, if I can get you with it.
Sure.
What time would that be? 9?
9 if she's on bail, 1:30 if she's going into custody.
October 25th would be fine, Judge.
9 a.m.
Yes, sir.
All right, court sets Ms. Smith for October 25th at 9 a.m. And that's for Mr. Smith. I'm sorry, Mr. Green.
Yes, it is.
Thank you, sir. We're all on source.
Yes.
Thank you, Ms. Smith. You're free to go. Are you ready to go? Mr. Robert? Yes, sir. Here is this. Yes, sir. All right, Zachary Wooten. CR 2255 and 56. All right, Mr. Wooten, if you will, sir, raise your right hand and say she. Mr. Wooten, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you got. All right. Your name is Zachary Taylor Wooten, is that right? Yes, sir. And Mr. Wooten, are you a United States citizen? Yes, sir. Do you read, write, and speak English? Yes, sir. Have you ever been diagnosed with a type of mental condition? PTSD. Okay. Are you currently undergoing treatment or on medication for this? Do you feel like the fact that you're not on medication, undergoing treatment, you still have a rational understanding about the proceedings here against you today? In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White's representation of you? Like you've had enough time to talk with him about both of your cases, in which you have had time to have all your questions answered. Is there anything about any of this paperwork that you've read over and signed today that you do not understand? Mr. White, do you believe that you would be confident today and that you explained to him his rights as it came to these papers?
Your Honor, I believe confident. I've had no problem whatsoever communicating with him about this case. I've explained his rights to him, completely waiving those rights, knowing that he tells him voluntarily. Court goes along completely with the placement of further adjudication. The note to the court that I explained the advantages and disadvantages of entering into such an agreement. Most notably, if he were to violate the agreement, the court would hold a hearing to determine whether or not he violated probation, and if the court found that he did so, he would be subject to the entire range of punishment on each case. On the first degree felony, up to 99 for life, it's minimum 5 and $10,000 fine. And third degree felony, 2 to 10 with $10,000 fine. I'm satisfied that he understands that and understands the gravity of the agreement which he's in.
All right, so Mr. Wooten, you understand what Mr. Wyatt has just articulated to the court regarding the range of punishments for each one of these offenses. Should the court approve the plea agreement today and place you on probation and any subsequent violation of that probation, you understand what you're facing? Yes. I'm of course going to find Mr. Wooten has been admonished as to the range of punishment for each charge. Mr. Wooten, as to the third degree felony offense charge of assault of a family or household member by impeding breath or circulation, how do you plead? Guilty. To the offense, first degree felony, burglary, habitation, and 10 other felonies, how do you plead? Guilty. Are you pleading guilty in each one of these cases because you are in fact guilty in each one of these offenses? Has anyone threatened, force, or pressure you to plead guilty here? The court will accept the defendant's plea of guilt at this time. Mr. Wyatt, any objections to the state's evidence? State's one?
No, sir.
State's evidence is admitted, and the court takes judicial notice of the defendant's judicial profession in each case. Anything further from the state?
I'm looking to see. We have additional notes regarding victim notification. Your Honor, it looks like the state is in compliance with victim notification. However, we have not received any response from the victim in this case.
All right, of course, I'm going to review the evidence. Read, please. Right, the court has reviewed the evidence. In each case, the court finds that there is sufficient evidence to convict Mr. Wooten of these offenses. The court will follow the plea agreement as recommended by the state of Texas. Court hereby defers a finding of guilt in each case. In the assault case, the court defers the finding of guilt, places Mr. Wooten on 2 years deferred community supervision. Orders him to pay a $1,500 fine, including $100 towards the family violence fine. Court will take into consideration under section 1245 DH 1 1163 of criminal mischief. Court will order this sentence to run concurrent with the probation in CR 2256 first degree felony offense of burglary to habitation. Court defers the finding of guilt, places Mr. Wooten on 2 years community supervision. Orders it to run concurrent with CR 2255 court or does not order a fine, but does order court costs of each cause of $290 and reimbursement fees of $35. So, Mr. Wooten, what's your plan after today?
Nothing I do with that. Yeah.
And what do you have to do?
Report. Yeah, whatever. I gotta do.
Do whatever they tell you to do and the things that they don't tell you to do. They're not gonna tell you every day not to commit crimes.
Well, I guess.
They're not gonna tell you every day not to drink.
I mean, it's really the first time I've been in trouble.
So you're gonna do the things they tell you to do, and you're also gonna do the things that you're not supposed to do, right?
Right.
And you understand that if you put me in a position to have to send you to prison, I may very well have to do. So. Okay, I just wanted to provide all that. Somebody back with thought.
Yeah.
All right, Mr. William, hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. You have you step forward to the deputy, will be fingerprinted, and after that, you'll report to the probation officer and they'll give you more information. Mr. DeWitt. Terry Lee DeWitt, CR 22129. All right, Mr. DeWitt, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you'll put your name down. Your name is Terry Lee DeWitt, is that correct? Yes, sir. Mr. DeWitt, you're represented in this case by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Yes, sir. I feel like we've had enough time to discuss this case with him and have all of your legal questions answered. Yes, sir. Is there anything about this pretrial intervention contract that you've read over and signed today that you do not understand? And Mr. DeWitt, are you a United States citizen? Yes, sir. And you do read, write, speak English, is that correct? Yes, sir. Have you ever been diagnosed with any type of mental condition? Mr. White, you believe Mr. DeWitt to be competent today? Have you explained to him his rights of this contract?
Yes, sir, I believe it's nothing positive, he understands the procedure opinion against him today. As the court would know, there's several waivers, most notably the waiver of jury trial. We know that I've gone over that. With Mr. DeWitt, I believe he's waiving that. I have a home voluntarily arrested his rights. I've explained to him you can't get that right back, and we're also signing stipulation of evidence, which makes the procedure very easy for the state should you violate the contract.
Thank you, Mr. White. Mr. DeWitt, you understand all of that? Yes, sir. You understand that you are waiving a right that's guaranteed to you today, in your right to a jury trial in this case. You understand that by waiving your right to a jury trial, you're telling the court that you're waiving your right to test the state's evidence and trial in front of the jury, to confront witnesses in front of the jury, and that once you waive your right, that right may not be restored to you. Understand that? All right, and in addition, you understand that you are also waiving your right to a speedy trial, and you're also waiving your right to have your criminal records expunged. If you successfully complete this contract, you will be waiving the right to have the DA's office, the probation office records in your case expunged. You understand that? Understand that all of those waivers you still wish to go forward. Okay. see here that this pre-trial intervention contract is for a period of 18 months on the offense of theft of property greater than or equal to 30,000 less than 150,000. That's safe, is that third degree now? That's not third degree. All right, and Mr. DeWitt, you understand that the range of punishment for this offense is, if convicted and sentenced to prison, is not less than 2 years, up to a maximum of 10 years in prison, and a fine not to exceed $10,000. That's potential range of punishment you would face if you were taken to trial and convicted in this case. This one. All right, court will find that Mr. DeWitt is eligible for the pretrial intervention contract. The court finds that Mr. White has joined in the waiver of jury trial, as well as the state waiving his right for a jury trial. That's the court will take all waivers in the PTI contract, approve the PTI contract. Will place Mr. DeWitt in the pretrial intervention program for a period of 18 months. Ms. Heisel, if you could sign this, I'm not here for me, I don't need that. All right, Mr. DeWitt, I'm going to hand this over to the probation department. You'll meet the chairman and every more. The first, do you want Mr. DeWitt, at least PTI, you want him outside waiting on you?
Yes, sir.
This, that's cool. Like, get somebody else out of it. See how it goes, 66.
Monty Travis Austin, CR 22-166.
Your Honor, we set a pre-trial today, talking to Ms. Heisel, we got it for 2 years last week, I just said it, I had time to review it. I'd asked for 30 days, he said I should go to the would also know, we had filed a motion to transfer this junior case, because I think it all be resolved at the same time.
All right, well, whenever I see that motion, order, I'll sign that, the judge will sign that. Court will reset Mr. Austin for, are you still dealing with pre-trial retreat? Or is that
I haven't.
All right, court said, Mr. Austin, you know, that 25th day, October 25th at 9 a.m. I'm free to go with you back on October 25th, and I believe it will be in the Canton. We'll be in Canton, probably in that small courtroom. Yeah, any others you're ready, Mr. White, or not yet? Or any other counsel that's ready? Not yet, so your name, sir?
Kelvin Rogers,
Roger.
I represent Mr. Christopher Long. And he is present.
All right, go bring your client. All right, this is CR 22-179, State versus Christopher Goins, and we're set for pre-trial. Ms. Rogers, do you have all of the discovery in this case if you received it from the DA's office?
Yes, ma'am.
Okay. Yeah, any issues on pre-trial?
No, yeah.
Do you anticipate any need for a contested pre-trial hearing, motions to quash, motions to suppress, anything of that nature?
No, yeah.
All right, then what I usually do, Mr. Rogers, is then once we make sure there's no pre-trial issues, then I'll set it for the docket call, and that's the time between pre-trial up to trial that I asked the parties to try to work out the case if it can be worked out. Otherwise, on a docket call day, then we'll just let me know jury trial, bench trial, or plea.
Okay.
Okay, all right, there being no, I think that's the pre-trials. If you have your schedule with you, once you look at a couple of dates. These are the dates I have available for reset. We have October 11th, 13th, and 25th. 11th, 13th, that's a Tuesday and Thursday of that week. 25th.
Let's do the 25th.
All right, Mr. Goins, I'm gonna reset you for a doctor call. October 25th, that'll be at 9 a.m. And Mr. Rogers, if you fill out this notice of reset, and then leave me the white copy and give a copy to Mr. Goins, and you'll be free to go. And once you fill that out, just have him sign it and leave it right there.
Okay.
Thanks, sir. Mr. Dobbins here. He was on his way over to the courthouse. Okay, that's fine. Are you ready?
I've got some cases right now that are gonna be reset. Got to about 3 pleas, but I'd like to do the reset ones to get those out of the way. So,
Who are you ready?
Jan Spino,
All right, Mr. Espino. Just have a seat. I'll call him. All right, Mr. Espino, this is file number CR 21-113, 114, 115, set for Dr. Caldwell, Mr. Brown.
Your Honor, we will need to have this set on a approach bench.
All right, court's going to reset Mr. Espino for so in November. About November 8th or 10th, Mr. White.
Let's go with 10.
Okay. All right, court's going to set Mr. Espino for a docket call and status. On November 10th. That'll be at 9. Usually, as long as I have the white one. I don't say, do you want a copy of the reset notice? Okay, yeah. So you can handle it, Mr. Rogers.
Thank you.
And Mr. Goins got one, right?
Yes.
Thank you, Mr. Espino. You're free to go. Thank you. Any others, Mr. White?
Code of, well, I just got them, I can go down the line, but what I've got next is Code of White.
Okay. Go to Lloyd White, CR 21-375, set for docket call, go ahead.
Well, Your Honor, we're gonna ask for one more docket call. I believe we're gonna have this resolved by the next time. Mr. Woodwhack has made an offer and he encouraged me to make a counter offer as well. So I believe that we would be able to have the same set and resolved on the next docket call once he gets back. It's
When did Mr. Woodwhite make his offer?
last week.
So Mr. White was he was unsuccessful discharge from PTI, so that's good.
Judge, I have notes from Mr. Woodward that he would like to just reset this to the October contested docket. If they don't have something worked out by then they can proceed on that failed PTI.
I have no problem.
Okay. All right, court will set Mr. White then for October 27th. That's the docket. I'll get it on it. Good.
Joseph Russian.
Introduction. CR 22-156 for pre-call.
That's correct, Your Honor. I was a little bit late getting the DVDs. If I could have one more pretrial on this, I believe we would be able to start negotiating. I did go ahead and file the normal pretrial motions that I normally do. I don't believe the state has any opposition to that.
Any objection from the state?
No, Your Honor.
Mr. White. Do you want the 11th, 13th, or 25th?
Let's go with the 11th.
All right. Court will set pretrial for October 11th. At 9 a.m.
Greg Beaver.
Mr. Beaver. All right, this is call number CR 2287, so docket call.
That's correct, Your Honor. I believe that we might be able to come up with a resolution. I'm curiously.
All right, can you tell me what the offer is? If one of you that Mr. Beaver rejected.
5 probated for 5 30 days condition probation.
All right, Mr. White, you've explained to Mr. Beaver that a rejection of that offer and the failure to reach any agreement on this day means that the court will not accept the plea agreement after today.
That's correct, Your Honor. We understand that.
Okay. All right, court will set Mr. Beaver then for jury selection. We'll begin that on Monday, October 3rd. Mr. Beaver, you'll report to the courthouse, and there will be members of my staff there. You won't go to trial that day, but you'll start the trial process. You'll continue to do that until your case is called for trial. Mr. White will not be required to be there if the case won't be going to trial on that day, okay?
Christmas back.
What was the last one again? What's that? Name, wasn't it?
Oh, Christmas back.
McBad, okay, I thought you said bad. That's a little bit bad. All right, call number CR 14-143, CR 14-302, or set on motion to revoke.
That's correct. It's my understanding the state has not gotten all the test results.
Your Honor, the basis of the state's motion to revoke is a new charge for which we are waiting for results from the lab. And it's essentially a sole basis. I think there's one other technical, but state is asking the court to reset this 60 days to allow us to get lab results back on the new charge. And I think that'll be just positive for all of it.
Okay. What was the result of Mr. McBad's UA? Did you give your best?
I was told.
Mr. Waddell?
Yes.
All right, then court, well, let's talk about that, Mr. McBeth. So you understand that, got a note here, that says that you haven't reported since June.
I had COVID the last time, and
What did you tell them that?
I called the probation department.
Or you told them that you had COVID?
Yeah, I had to send them a picture of the test and stuff.
So how long did you have COVID?
I had it for a week, but I couldn't be around anybody for 12 days.
So what happened to the whole month of July, the whole month of August? All the way up to today?
I repeated, I was one time and she wasn't there. And I told the caller, I would never get up with her. Then it's time for the next 4 days, and I had the COVID. And I tried to call this last month, but I couldn't get hold of it. I'm usually, I was worried every time. It's the whole thing through it all.
And you understand that you have to report even when you're not in court. They don't just report just when you come to court. You report monthly, is it correct? Yes, all right. So I don't want to see any more, hasn't reported, hasn't done this, hasn't done that. Okay. All right, court's going to reset you for the contested docket. They set that November 29th. 9 a.m.
Carlos Hernandez.
David,
Carlos Hernandez.
Mr. Hernandez. CR 22-147, State versus Carlos, Jerry Hernandez. What's up for pretrial?
Your Honor, I believe we could go ahead and set this on a docket. I believe it will be resolved next court date. There is something that I'm needing from the state, but it would not be something that I would be needing to file any pretrial motions in regard to. It would be something that would make the case either positive or negative for us. But preliminary negotiations, I believe we're pretty much on the same track.
All right, court will set Mr. Hernandez then for docket call on October 11th. It'll be at 9 a.m. Once you sign and give your copy, Mr. Hernandez will approve it.
The last as far as the passes judgment Carroll.
Mr. Perry. That's really Perry, CR 2273. Mr. Perry set for docket call.
Your Honor, we actually have come up with an agreement, but we just don't have the paperwork. If we could have this reset for us to go ahead and take our plea, we appreciate that.
Would that be a plea to probation or time?
Probation.
Probation. All right, court will set Mr. Perry then for October 11th at 9 a.m. I believe we may be back here, Mr. Perry, in the same court. Unless something grandiose happens between now and then.
Your Honor, I do have plea papers done on one case, Danny Smith.
Would you double check?
Well, if you look at my call, you're some years out.
No, there's just as a heads up, there's a tax statement on this that was sent, but I know we're not in our normal place, so do you have access to that, or do I need to? Okay.
I've got a copy of it as well.
Ms. Hazel, I have reviewed the legal impact statement in this case. I've signed that. I'll return that to you. All right, Mr. Smith, you'll raise your right hand. I'll place you on oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so be done?
Yes.
All right, your name is Danny Bruce Smith Jr., is that right?
Yes.
And Mr. Smith, are you a United States citizen?
Yes.
You read, write, speak English?
Yes.
And have you ever been diagnosed with any type of mental illness? Now, I just read in the victim impact statement that you were under some type of influence of a new prescription medication for anxiety. Is that correct?
Yes. Yes.
Is there anything that's related to your mental health?
No, it's not really, just like now we're just have a little issues.
Okay. That's fine. That's fine. You answered my question. All right. And so, Mr. Smith, in this case, you're represented by your attorney, Mr. Jeff White. Are you pleased with his representation? You feel like you had enough time to talk with him about this case and have all of your legal questions answered? Is there anything about this paperwork that you read and signed that you do not understand? No, I don't understand everything. Mr. White, do you believe Mr. Smith to be competent today? Have you explained to him his legal rights as it pertains to this case?
I did, Your Honor. I believe he understood him. I believe he's competent to make any decisions that need to be made today.
All right, Mr. Smith, I see that you were originally indicted with the third-degree felony offense of assault of a family or household member with a previous conviction. However, it appears that the plea agreement you've reached with the state today is that you will be guilty to the lesser included Class A misdemeanor offense of assault causing bodily injury to a family member, with your punishment being assessed at 1 year confinement in the county jail, with that being suspended and being placed on community supervision for 2 years. In addition, you would have a $1,500 fine, court costs, and reimbursement fees. Is that your understanding of the plea agreement?
Yes, sir.
All right, Mr. Smith, the range of punishment for a Class A misdemeanor offense such as this is a maximum 1 year in jail and a maximum fine, if imposed, not to exceed $4,000. So I would find that this plea agreement would legally fit within that range of punishment. So at this time, Mr. Smith, I would ask you how you plead to the Class A misdemeanor offense of assault causes bodily injury of a family member. Are you pleading guilty to that crime because you are guilty of that crime for no other reason?
Yes.
Has anyone threatened, force, or pressure you to plead to this crime today? Right. Say again. I haven't had a threat. Okay, so no one's twisting your arm, making you feel like you have to do this. All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the admission of state's evidence? No objection. State's evidence is admitted and court takes judicial notice of the defendant's judicial confession. Anything further from the state, the court will note again that it has reviewed the victim impact statement in this case, which seems to be supportive of the plea agreement reached by the state.
Yes, Your Honor, nothing further.
From the defense. All right, court's going to review the evidence briefly. Turn your phone off. Courts reviewed the evidence and we find enough evidence to convict Mr. Smith of this offense. The court will follow the plea agreement as it's been recommended by the state. There's to be in compliance with the victim's wishes in this case. Court hereby convicts Mr. Danny Bruce Smith Jr. of assault causing bodily injury to a family member. Assesses his punishment at 1 year confinement in the county jail, suspends that sentence, places him on community supervision for a period of 2 years, orders him to pay a $1,500 fine. Court also imposes special conditions of community supervision to include mental health conditions. Court costs of $270 and reimbursement fees of $35. Did she divorce you?
No, trying to work this out, and it just can't get it coordinated.
I think I know why she doesn't want to work. After reading this, I'm surprised she said in there that she filed for divorce, right? She deserves a lot better than that, my friend. A lot better. I think you're very lucky man today. I think the jury would have sent you back to prison for a long time. So I want you, hope that's sobering to you. Hope that's real sobering to you. So, Mr. Smith, if you violate any term of this community supervision, how long is your sentence in jail? 1 year. 1 year. Don't come in here asking for 6 months or 9 months or 3 months. Okay, 1 year. Sentence is imposed today. 1 year. You screw up, you go to jail for a year. And I'm gonna make sure the sheriff doesn't give you any good time or anything like that. Understand? I know it's fine. I'm telling you it's fine. I'm telling you what my expectations are of you when you leave today. I'm not pleased after reading this at all. All right, Mr. Smith, come forward, be fingerprinted by Deputy Everett, and we'll report to probation department.
I've got 2 other cases that I have got paperwork.
Okay. Mr. Everett, are you ready?
Yes, Your Honor.
Paperwork.
There's not gonna be paperwork today.
Oh, I thought that's what we were waiting on.
We were waiting on.
Oh, we were waiting on. Thursday. That's not a good time.
Your Honor, I believe, we need to take, an update for pre-trial release, and then we have an announcement about plan moving forward.
Okay, do you need me here, what they'll, or fighting this?
I believe it's, on the third.
All right, this is CR 32-113, state versus Alejandro Mota. There's stuff without the law possible. Ms. Heisel, did you want to put Officer Mature under oath, follow his witness?
Yes, Your Honor.
And if raise your right hand, do you swear that the testimony which the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Speak up loudly for the voice.
Thank you, Your Honor. Officer Material, would you state for the record what your job title is? I'm a probation officer. And as a probation officer, here at Van County, yes, is one of your duties to assist with drug testing on pretrial release? Yes. And today, do you have occasion to test Ms. Alejandro Mota as a condition of her pretrial release? I did. What were the results of that test?
The 5 panel showed that she's positive for methamphetamines and opiates.
Your Honor, pass witness.
Mr. Everett, any questions?
No questions, Your Honor.
Any further evidence?
No, Your Honor.
Thank you, Officer Mature. Dave, you said you had an announcement.
Your Honor, the state is going to ask that Ms. Mota's bond be held insufficient at this time. I believe we are going to have an agreement at the next setting, but we are unable to get that paperwork done today. And I do believe that that agreement is going to include safety as a condition of a deferred probation. And so we would ask the court to take our motion today, hear our motion today, and then reset next month for.
Your Honor, that's correct. An offer has been made that would be deferred probation with safety as a condition. I've discussed that with my client. I think between now and the plea setting, we'll firm up the details and have paperwork ready and get the case closed out in the next session.
All right, then, based on the evidence before the court today, through the testimony officer, ensure the court's gonna find that Ms. Mota has in fact violated the conditions of her pretrial release. The court's gonna find her bail to be insufficient at this time for those positive test results. Court is going to have Ms. Mota taken into custody at this time. Court's gonna set her new bail at $150,000. Court will reset Ms. Mota. October's the end of the month.
Give me one moment, please, Your Honor.
Yes, sir. Look at the week, October 11th, 13th.
And this would be, if she's in custody, it's one of these.
Maybe one.
Your Honor, let's go ahead and do the 13th.
13th.
Yes, sir.
All right, Ms. Mota. Set you for plea, docket call October 13th. At 1. And that'll be at the Manatee County Justice Center.
Okay, the main court.
No, it'll be at the Justice Center out of the jail, so I'd be removed for in custody.
Okay.
So now if Ms. Mota posts this $150,000 bail, then it would be, that day would be, we said what, the 13th, we said, 13th or what?
13th.
13th. Yeah, that will be a court out if she posts that.
Okay. The Justice Center is where the jail is located.
Yes, sir.
Sorry, that's not.
Yeah. All right, this one's first. Or you be taken in custody at this time.
That'd be excused, Your Honor.
Yes, thank you.
We'll just sort of bring it back for next.
Are you ready?
Yes, sir.
Let me get your line.
I'm ready to go. I've got two pleas. If you want to start with them.
Yeah, let's do this. Your front house. All right, is the plea today taking into account the warrant that he's in custody now?
Judge, it's my understanding, the warrant was for a criminal trespass. There is a 1245 language pertaining to a criminal trespass in here. We believe that should resolve all of this business, including the warrant.
All right, this is State of Texas versus Kenneth Dan Funnerhouse, CR 22133. Mr. Funnerhouse, does you barely raise your right hand? Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So, all right, go again. Your name is Kenneth Dan Funnerhouse Jr., is that correct? And Mr. Funnerhouse, are you a United States citizen?
Yes.
And you do read, write, speak English, is that correct? Have you ever been diagnosed with any type of mental condition? You gotta let me finish, and then you have to say out loud so she can write it down. Okay? Have you ever been diagnosed with any kind of mental condition? Okay. In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation?
Yes.
Like we've had enough time to talk with him about your case, to have all the questions answered. Yes, anything about this paperwork that you've read, signed that you do not understand. Mr. Schmidt, do you believe your client will be competent today?
I do.
You've explained to him his rights as it pertains to this case.
Yes, sir.
All right, so it appears here, Mr. Fronterhouse, that you, the original charge, possession of marijuana.
No, Judge. Originally, Mr. Burnhouse was arrested for that criminal trespass, and he was charged with prohibited substance in the correctional facility. And we're looking to also include it in that.
All right, Mr. Fronterhouse, the plea agreement is that you would be pleading guilty to a Class B misdemeanor offense in possession of marijuana less than 2 ounces. A Class B misdemeanor does carry a range of punishment of confinement up to 180 days and a $2,000 fine. You understand that? The plea agreement appears to be that you would plead guilty to that offense in exchange for the state's recommendation that your sentence be 5 days in the county jail, that you receive credit for time served, that you pay a $500 fine. State is dismissing under section 1245 a Class B criminal trespass and felony prohibited substance in correctional facility. So that he had,
No, it's not necessary to have the 1245 language on prohibited substance. This should be less included into that, Judge. But we had the judgment correct, and she had that language, and I couldn't imagine it hurt, so. If there's another one, we'll have that 1245 as well.
okay. There would be reimbursement fees, Mr. Fronterhouse, of $535 plus court costs. Is that the plea agreement you want the court to approve?
Yes.
Mr. Fronterhouse, then, how do you plead to possession of marijuana less than 2 ounces?
Yeah.
Pleading guilty to that crime because you are guilty of committing that crime? If anyone threatened, force, or pressure, you plead guilty?
Yes.
All right, court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No, okay.
State's evidence is admitted. Court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense?
No.
All right, court reviewed the evidence. If we find sufficient evidence to convict this defendant, the court will follow the plea agreement in this case. The court hereby convicts Kenneth Dan Fronterhouse Jr. of possession of marijuana less than 2 ounces, Class B misdemeanor. Court imposes sentence at 5 days confinement in the county jail, awards him 5 days credit for time served. Orders him to pay a $270 court cost, $500 fine, $535 reimbursement fees. Court takes into consideration and dismisses a Class B criminal trespass of even date. Mr. Fronterhouse, when do you think you'd be able to pay the county what you owe all of these fees?
Yeah, I can pay it out.
So like,
Coming up with all that. Comes out.
I'm saying, how long do you think it would take you to pay what you owe?
Oh, what, 6 months maybe?
6 months. All right, so what I'm gonna do is I'm gonna order you to report to the Van Zandt County Courthouse before. Do you have a job? Okay, I'm gonna order you to report to the Van Zandt County Courthouse before 5 p.m. today. And I want you to meet with Ms. LaPrade, the court compliance officer, and I want you to make a payment today.
Okay.
Towards your fees, and then whatever you don't pay, I want you to set up a payment plan. And you gotta meet with Ms. LaPrade to set that up, and that's gotta be done before 5 p.m. today at the courthouse. You understand? Mr. Fronterhouse gonna be booked in on a criminal trespass, so he's gonna be released.
Judge, I would prefer you be released, but I'm uncertain. I think that when you were talking with the DA's office, they're trying to trace the origin of the warrant. I do know that these charges originated from the criminal trespass.
And he hasn't been arrested on this.
Yes, that's my
Have
understanding.
his fingerprints.
Judge, and quite honestly, I didn't know that he was booked in to the Van County Justice Center on a criminal trespass warrant. It was an onside. And so he was booked at that point. That was at the time that the prohibited substance charge originated. So I couldn't imagine that they didn't, but knowing the issues, it would surprise me that they didn't clear that up.
That's our understanding as well, Your Honor. We believe that this is probably should have already been cleared out. This, I believe is trying to track that down. But we do intend for, Mr. Fronterhouse to have time served credit and be released today from all charges.
Kind of concerned about the CJIS tracking. Because we won't have him under our thumb to get his fingerprints. It's gonna leave an open issue. CJIS.
And Judge, I would suggest to the court that, as well as being able to meet with Mrs. Crabbe, the order to go over and do the booking process for criminal charges. If you want to, it's clear. I mean, normally, I think under the circumstances, it's not due to any his fault. They should have heard that when they arrested him on that charge, but with the CJIS concerns, I believe being booked in and booked down will take care of it.
So what I'm gonna do, Mr. Fronterhouse, is I'm gonna sign a fingerprint order. I'm gonna let you get out of custody.
Sure.
And I'm gonna give you an order and you're gonna go over to the jail, you're gonna show it to them. And if they need your fingerprints, they're gonna take your fingerprints. Okay.
And Judge, I will relate to the court that based on my discussion with the DA's office and Mr. Fernhouse, we cannot determine, it's our belief that this one originated in February 2022, and nothing else has arisen since then. So that's when we're relating to the court. Now, if there's something additional that we're unaware of,
Yeah. So
just so you know.
I'm gonna, yeah, I appreciate that and say you agree, so I'm gonna let it up to you. I'm gonna go see. Order. All right, so Mr. Fronterhouse, we're clear. I'm gonna let you out of custody. All right, I'm gonna give you an order. I'm gonna sign that. You don't leave until you get it. All right, and then you're gonna go to the jail. You're gonna tell them you're gonna show them that order when you get there, and they're gonna take your fingerprints if they need it. If they don't need it, they'll send you away. Okay. All right. And please let it go ahead and have a seat out there, and I'll bring the order in just a minute. Oh, I'm sorry, Mr. Fronterhouse, come up here. Get fingerprinted on this document. All right, we got
Judge, we got a plea on Mr. Mota, who's here.
Stephen Maya, CR 22154. All right, Mr. Maya, if you'll raise your right hand. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so if you got?
Yes, sir.
All right, you put your hand down. Your name is Stephen Daniel Meyer, is that right?
Yes, sir.
And Mr. Myatt, are you a United States citizen?
Yes, sir.
And you read, write, speak, and read?
Yes.
And have you ever been diagnosed with any kind of mental condition?
No, sir.
You're represented by your attorney, Mr. Schmidt. Are you pleased with this representation?
Yes,
Doc, you've had enough time to talk with him about this case and have all your questions answered.
yes, sir.
Anything about this paperwork that you've read and saw today that you don't understand?
No, sir.
Mr. Schmidt, you believe Mr. Myatt to be competent today, and you explained to him his rights regarding this case?
I did. I did.
All right, Mr. Myatt, it appears that you have been charged. You've been charged by indictment with a third-degree felony offense of possession of a controlled substance between 1 gram and 4 grams. However, it appears that the plea agreement is that you would plead to a lesser included offense today of possession of controlled substance, a state jail felony under section 1244A of the Texas Penal Code. Your punishment would be assessed at 4 days in the county jail. You would receive credit for those 4 days and would be ordered to pay your fine, court cost, reimbursement, and restitution. You understand that if the court goes along with this plea agreement, you would be convicted as a felon today and you'd be punished as a misdemeanor offense. You understand that?
Yes.
Understanding the range of punishment, and the plea agreement, you still wish to go forward?
Yes, sir.
All right, Mr. Myatt, then I'm gonna ask you this time, how do you plead to possession of a controlled substance, penalty group one B, less than 1 gram, a state jail felony under section 1244A?
Guilty.
Plead guilty to that offense because you are guilty of committing that offense and for no other reason.
Yes, sir.
Has anyone threatened, force, or pressure you to plead guilty today?
No, sir.
Court will accept the defendant's plea of guilt. Mr. Schmidt, any objections to state's evidence?
No, sir.
State's evidence is admitted, the court takes judicial notice of the defendant's judicial confession. Any further from the state, Ms. Humble?
No.
Nothing further from the defense, Mr. Schmidt?
No, sir.
Mr. Myatt, when do you think you could pay off everything that you owe the county?
4 to 6 months, sir.
And can you make any kind of payment today?
Yes, sir.
What do you think you can pay today?
200 to 300.
200 to 300? All right, Mr. Myatt, the court has reviewed the evidence. I do find enough evidence to convict you of this offense. The court will follow the plea agreement in this case. The court hereby convicts you of that offense, such as your punishment to 4 days confinement in the county jail under section 1244A. Court issues you credit for 4 days, orders you to pay a $750 fine, $180 restitution, $290 court costs, and $535 in reimbursement. Court will order you to appear at the Vandy County District Clerk's office today to pay $250 towards the fines and fees that you owe. After which, I want you to walk down to the other end of the hall, opposite of the clerk, and meet with the court compliance officer to set up a payment plan to discharge the rest.
Yes, sir.
Okay. All right, Mr. Mine, you give our remainder to the custody of the Vandy County Sheriff, so we carry out the terms and conditions of the sentence. Have you step forward here, Deputy Everett, to be fingerprinted, after which I want you to get a copy of this. Here we go. Thank you. Like that.
Just we can, without others.
Charles Bennett, CR 22-125-238. Mr. Bennett is set for doctor's call today.
That's great, Judge. We're gonna ask for a question about the trial, quite ready to ask for the trial.
Well, and I see that Mr. Bennett's set for pretrial on the more recent page 238. Any contested pretrial issues on that?
No, it's not this time on that case, Judge. I would ask State Court, pre-trial notice to be previously necessary, but if we want to.
All right, court will grant that, it was showing a good cause. The court will set Mr. Bennett in for docket call in each case. Got 11th, 13th of October.
October 11th.
Court sets each case October 11th. It'll be at 9 a.m. Mr. Bennett, once you sign, get your notice, you'll be good.
Judge, and I heard you mention earlier the location of these. Have we settled the October location?
I believe October 11th, right now, it's tentatively scheduled to be back here. However, if something opens up that closer to the courthouse, then we may have to notify everyone again. And you can rest assured that we'll be notifying your attorneys and your bondmen prior to board if we change. Okay? Let's get, Savannah Cooksey. Ms. Burns, do we have an update on this? How you doing? All right, Ms. Cooksey is set for Docket.
That's correct, Judge. I think before we were last time, we had some pre-trial issues. Ms. Cooksey was taken into custody. At that point in time, we announced before that we got additional documents for the state. Obviously, Ms. Cooksey was able to do that. So we'd ask for some additional time to continue to file the documents for our case.
State's on the post.
Ms. Cooksey, what was the result of your UA? Clean, it's good news. All right, Ms. Cooksey, court going to grant your request. We're going to reselect this. We want that same day, October 11th.
That should be fine.
All right, court sets Ms. Cooksey then for docket call October 11th at 9. Stay clean, Ms. Cooksey. Jeremy Hester, DR 21291. Judge accepted pre-trial.
It should have been having contested pre-trial this time. I specific doctor call.
All right, court sets Mr. Hester then for docket call on October 11th. That'll be at 9 a.m. Mr. Hester, are you making payments on your old case? I show you're delinquent on that already.
I have my lawyer, thought I was supposed to bring it.
If you'll go to the courthouse and make that payment, then that'll put you a good note on my docket. All right. Joey Lamone, CR 22108. Set for pre-trial.
This time, I said, check that doctor call.
There being no contested pre-trial motions, court sets Mr. Lamone for docket call October 11th at 9. Once you sign and give your notice, you're free to go. Jennifer Rollins. Is there a Jennifer Rollins? She outside.
Yeah, just one out.
Oh, yeah, we'll move on. We'll Dugan Toms. CR 22158. Mr. Toms is set for Dr. Tom.
That's correct, Judge. Negotiating with the state, it's ongoing with us.
Any objection from the state?
No, you're on.
All right, court will set Mr. Toms in for Dr. Kamal on October 11th at 9 a.m. Once you sign, get your notice to free to go. Straight off. I get it. Yeah. About one second. Nicholas Dubberly. Oh, I'm sorry. That's not Mr. Schmidt. I'm sorry, Mr. Just have a seat. I'm sorry. Your attorney is on Zoom, so I'm gonna call you just on, okay?
Yes,
Right, so we still have things for that. Jimmy Booker.
I got him, but I got Garrett Joslin, Jennifer Rogers, Juan Gonzalez.
Hang on, Mr. Booker. All right, let's go, Joslin. So we have an issue on Joslin in that are you retained in that group?
Yes.
So we don't have a letter of rep or anything in the clerk's file, so that's why your name's not pulling up on.
Yeah, we waived the rent on that one, so it should have been entered from that direction, but we'll make sure to do it.
Yeah, if you don't mind.
No problem.
All right, this is CR 22-149, State of Security, Joslin, set for Dr. Paul.
Judge, right now, we're still negotiating the state ask for additional document.
States have proposed.
All right, there being no opposition, state, or the court sets Mr. Joslin for Dr. Call October 11th. That will be at 9 a.m. Mr. Joslin, once you sign and get your notice, you're free to go. Mr. Gonzalez. CR 22-241. You've been given a copy of the indictment to Mr. Gonzalez.
I have, we reviewed it. Mr. Gonzalez is aware we're in charge with his name is spelled correctly, wait for the reading, and I'm believing that he'll be asked to pre-cross that. October 11th.
So I can give you more time if you need more time.
That's fine, if you have a Tuesday in November, that'd be great.
Let's see here. We've got, okay, the first Tuesday would be
November 8th.
for that.
Yes, sir.
All right, court finds that Mr. Gonzalez has been found indigent by the court, has appointed Honorable Richard Schmidt to represent Mr. Gonzalez. The court finds he's waived the formal requirements of arraignment. Court will enter his plea of not guilty to the record. The court will set Mr. Gonzalez for pre-trial on November 8th at 9 a.m. And Mr. Gonzalez, have you signed any conditions of pre-trial release yet?
They haven't got their response to documents, Judge.
Not yet, no.
Yes, sir.
Oh, he has to sign the signature on the
They
letter.
are signed.
Perfect. All right, good. Check that off. All right, then once you get your notice from Mr. Schmidt, you're free to go. Okay.
Judge, I'm also standing in on the gender for Mr.
To John. To John.
For John.
I've butchered Mr. LeJohn there so many times, but now I know what it is.
It was found I did it everywhere.
Well, like I said, I've done it enough that I've. All right, this is cause number CR 21402, Say versus John William LeJohn Jr. Set for pretrial court, recognized Mr. Schmidt standing in for Mr. Manning.
That's great. And I spoke with Mr. Manning and he stated that it's now that we can naturally contest the pretrial motions at this time as the motion set for the call. I believe he's doing a Thursday docket.
All right, court will set Mr. LeJohn in the docket call on. You say you wanted that October date,
The Thursday.
the 13th? Mr. LeJean, while Mr. Schmidt's filling that paperwork out, I show that you're delinquent on the pretrial release fees and that you failed to report in August.
I was sick with COVID. I just gave him copies of this and I called him, tried to go to another meeting time and the guy called back from, I've been having phone issues, so I'm still having phone issues. I'm trying to resolve. But I have money. After I got gonna be sick, I got another employer. I'm self-employed too. It's a home. It's doing work for her. She's the one actually driving.
Okay, so how much money do you have today?
$70.
So what I want you to do, you're delinquent $230. So
For the attorney fee, yes, because I don't know if they're separate or they're all together. Like I paid,
you'll pay the pretrial supervision office.
just give them
When, or,
I didn't know if I had to keep them separate.
No, you don't. So what I'm gonna do is I'm gonna order you, you're gonna get your reset notice for Mr. Schmidt for October 13th. And I want you to report to these officers over here. And you can make a payment there or take their instructions on how to make a payment. Yes, sir. They'll tell you what to do. Over here to Ms. Burns, if you're interested. All right, you ready for Mr. Booker? Sure. Mr. Booker, come on up. Jimmy Saul Booker. I'll play Sal Booker, CR 22239. All right, let's see here, Mr. Booker. Mr. Booker is set for arraignment today, is that correct? Mr. Schmidt?
Well, Judge, he is up and around, but Mr. Booker filed a request to have me removed, and I filed a motion to withdraw as an attorney's record. So since that time, we have not looked at the indictment and maybe we could proceed on that. And then, based on the court's ruling, we can go from there.
Mr. Booker, do you want to hire your own attorney?
I'm gonna represent myself.
You're gonna represent yourself? Before we go down that path, have you thought about that?
Yes, sir, I've already been advised of the dangers and disadvantages under other versus state. I've done some representing myself in civil and criminal procedure.
You represented yourself civilly in criminal proceedings? What is that?
In Sherman, Texas, and in Kaufman County.
You represented yourself in criminal cases? And have you gone to trial?
Maybe this starting this.
Have you ever gone to trial?
Yes, I, in a civil proceeding, correctional officer, I took correctional.
Have you ever gone to trial representing yourself in a criminal case where you're facing up to 20 years in prison?
Yes, sir.
And when did you do that?
I haven't done it, but I'm not afraid to tell you.
Listen, Mr. Brooks, my question is, have you represented yourself in a criminal trial at all?
Yes, sir.
Okay. Have you represented yourself in a criminal trial where you're facing prison time?
Yes, sir.
Have you done so when you're facing up to 20 years in prison?
Yes, sir.
Okay. When did you do that?
This was in '86. Yeah, Sonia Wallace dismissed the charges.
And that was that trial?
Yes, sir.
Was it a jury trial?
So it was at a hearing before him.
Okay. And so you're asking the court to allow Mr. Schmidt to withdraw.
Right.
And you want to represent yourself. You understand that if the court does so, then you'll be held to the same requirements as the state's attorneys regarding the rules of evidence.
Yes, sir.
Criminal procedure. And you think that that's a good idea?
Yes, sir.
You do. Why do you think that's a good idea?
Well, one of the reasons is because the charges that I charged with a failure to register, and I provided him, he had that information for him. I told him that all he had to do.
No, this has nothing to do with Mr. Schmidt. I want to know why you think it's a good idea for you to represent yourself. Nothing that you
Okay.
talked about.
Let's see, if I had been in his shoes, then he would have been released.
I want to know why you think it's in your best interest for you to represent yourself. I don't care what your allegations are about Mr. Schmidt or not. I want to know, you're asking me to allow you to represent yourself. You tell me why you think that's.
I understand how the system works. I understand that when court appointed attorneys will then be direct or given cases, that their bills, the food that they buy, that all comes from the district attorney. He's not fighting against the state. He's basically a plea bargain representative. And I've seen enough to know, and I've had the practice and experience myself to know that I can represent myself better.
Okay. I'm not going to correct you where you're wrong. I'm just going to take what you say to be the reasons why you think it's in your best interest.
I appreciate that.
So what I'm going to do today is I'm going to pull up the indictment. I'm going to arraign you, and then I'm going to set you for pretrial. And then we're gonna come back and go, I want to go over the warnings with you at our next setting. I don't have those here with me today. And we're gonna fill out that paperwork and we'll allow you to represent yourself.
Could I say one other thing? I've already made bail on this case. Because the initial charge was for failure to register. Here's the documents, I have it, documents where I made bail on it. So it looked like I'm being put twice in the jeopardy for the same offense where the district attorney later on attached the Facebook account.
Now, we're not here to argue merits of the case. We're not at trial. If you, it's obvious that you're on bail because you're not in a jumpsuit and handcuffs.
Right.
So what's your point about you having made bail?
Why is this arraignment here? And if I already been arraigned for?
Do you understand the difference between arraignment and trial?
Yes, sir. When I got arrested, I went before the judge and got arraigned.
Right,
But then I made bail right here.
right.
So where am I going?
You were magistrated, okay? When you went to jail, you were magistrated, okay?
What's the difference?
That's where they advise you what you're being charged with, so that you understand that you have the rights to an attorney. And all of those things. What's going on here today is that, hang on, is that you've been formally indicted by the grand jury. And we're set for arraignment today to affix your identity in the indictment. And to find out if you're going to represent yourself, or if you're seeking counsel or appointed counsel.
Okay, I don't understand. But I thought the arraignment was when you said the bail.
So what we're gonna do is I'm gonna set you for pretrial. We're gonna come back to court. We're gonna have our warnings. We're gonna go over all that paperwork and put you back on the record. And we'll let you prosecute your case going forward, or we'll let you defend your case against the prosecutors going forward, if that's what you want to do.
That's what I want to do.
Okay. And you understand that it's always in person's best interest to hire an attorney or have an attorney, if they can't hire one, to advise them and assist them during their trial. You understand?
It's not that.
Okay. All right, well then, can we give Mr.
And Judge, just for the record, the court granting my motion to withdraw.
Court grants your motion of withdrawal, Mr. Schmidt? Thank you. And let's see, can you put me on an indictment for Mr. Booker? I'm gonna have you sign right here. Okay, we're gonna come back on this date, October 10th at 9 AM. And literally for the purposes of pretrial, and we're gonna go over your self-representation. Okay. I'm gonna give you a copy.
When you write that, when you send me an order showing that I'm gonna have to represent myself, we're gonna try to do a motion.
We're gonna do that at the next year, because I don't have my warnings with me today, and so I've granted his motion to withdraw. You and I are about to go over the indictment in this case. We're gonna enter your plea. And we're gonna set you for pretrial. All right, Mr. Booker, and cause number CR 22239. You have been indicted by the Vanderbilt County Grand Jury of the second degree felony offense of failure to comply with sex offender duty to register for life 90 days. The state has alleged prior convictions and enhancement paragraphs, which if proven true, would elevate your potential range of punishment to a minimum of 25 years to a maximum of 99 years or life confinement in the Texas Department of Criminal Justice. This time, Mr. Booker, do you waive the formal reading of the indictment, or do you want the state to read that out to you?
I like the state to do that.
Ms. Heigl?
Thank you. In the name and by authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected and panel sworn, charged, and organized as such at the July term, AB 2022 of the 294th Judicial District Court for said county, upon their oaths, present into said court at said term that Jimmy Soul Booker hereinafter filed the defendant on or about April 23rd, 2022, and before the presentment of this indictment, in the county and state of Forsyth, did then and there, while knowing that he was required to register under Chapter 62 of the Texas Code of Criminal Procedure because of a reportable conviction based upon aggravated sexual assault, and after having established a new online identifier not already included on the defendant's sex offender registration form, namely a Facebook account under the name Jimmy Booker, failed to comply with the requirement of Chapter 62 by failing to report to the defendant's primary registration authority, namely the Wills Point Police Department, and the defendant failed to report the establishment by the first date that the law enforcement authority by policy allowed the defendant to report. Enhancement paragraph 1. And it is further presented that prior to the commission of the charged offense, hereinafter styled the primary offense on the 8th of April, 1985, in clause number 13,380. In the 294th District Court of Van Zandt County, Texas, the defendant was finally convicted of the felony offense of burglary of a habitation. Enhancement paragraph 2. And it is further presented that prior to the commission of the primary offense and after the conviction in clause number 13,380 was final, the defendant committed the felony offense of robbery and was finally convicted on the 12th of February, 1986 in clause number 14,745 in the 86th District Court of Kaufman County, Texas, against the peace and dignity of the state.
Thank you. And Mr. Booker, I want you to review this indictment. Is your name?
I have a copy.
Okay, well, I want you to look at it. Is your name still correct in this indictment?
Yes, sir.
Okay, and what did you plead, guilty or not guilty? All right, the court will find that Mr. Booker has been formally arraigned. The court will enter his plea of not guilty into the record. Court will set this matter for pretrial on October 11th, 2022 at 9 a.m. At that time, Mr. Booker, court will address your warnings that are required for admonishment purposes, and we'll proceed on that day.
Okay.
All right.
Y'all have an answer.
All right. And do we give him a copy of the notice of that?
I have a copy of it.
All right, Mr. Schmidt, do you have any further?
I have Jennifer Rollins.
Mr. Rollins? For a new appointment, Mr. Schmidt.
Well, Judge, I believe it was up there, I guess that's, so, just wrong.
Let me share this. This is cause number 0.336 at forward. Go ahead, Mr.
Correct, Judge. I received a copy of the indictment. Her name's both correct. We stand with charges on it. We wait for reading, plead not guilty, and ask to be set for a pretrial date on October 11th.
All right, court will find that Ms. Rollins has been appointed counsel on the basis of indigency. Is represented by the Honorable Richard Schmidt. The court finds that Ms. Rollins has waived the formal requirements of arraignment. Court will enter her plea of not guilty into the record, set pretrial. Did you want that October, November date?
November, the November date, Judge.
All right, that is November the eighth. Yes, that'll be November eighth, Tuesday night. Pretrial. Do you know, Mr. Schmidt, if Ms. Rollins has signed her pretrial release petition?
I believe so. Yes, sir.
Okay, thank you. All right, Ms. Rollins, you understand what you're required to do on your conditions of pretrial release?
Yes, sir.
Okay, you're free to go. We'll be back in November. In your building.
Yes.
You may be excused.
Thank you.
Mr. Deverly. Come on up, sir. Let's see if I can get you. If he comes on, we'll be able to see him there, I believe, okay. There's, and if you need to get closer to that, you can. I believe the Vast of the Toronto's. Mr. Shoemate, if you're there, can you turn on your device, please? A minute ago, he said he was having problems, he was calling, so he was having problems logging in. Well, he's been here for quite some time, and I'm just waiting for the other attorney to speak. I'll tell you what, just go ahead and have a seat, I'll call you back up. I'm gonna leave him here, so when he pops in, I'll call you back up. Yes, okay, thank you. Appreciate your patience. Yes, sir. Mr. Wyner, is it still with you right here? Yeah, come on up. All right, Mr. Cashion. All right, Mr. Cashion, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. All right, you can lower your hand. Your name is Leland Oliver Cashion, is that right? Yes, sir. And Mr. Cashion, are you a United States citizen?
Yes, sir.
And you do read, write, and speak English, is that right?
Yes, sir.
Have you ever been diagnosed with any type of mental condition? You're represented by your attorney, Mr. White. Are you pleased with his representation of you?
More than.
That's great. I'm glad to hear that. Are you, you feel like you're confident that you've had enough time to talk with Mr. White about your case and all of your legal questions answered? Is there anything about this paperwork that you've read over and you signed with him today that you don't understand? Mr. White, you believe Mr. Cashion to be competent today?
Yes, I do.
You've explained to him his rights, as they pertain to this case.
I have, Your Honor, I fully understand.
All right, Mr. Cashion, it appears that you were. Appears that you were originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon. But the plea agreement today is that you would plead guilty to a lesser included Class A misdemeanor offense of assault causes bodily injury to a family member. You need to know that the range of punishment for a Class A misdemeanor is confinement in the Van County Jail for up to 1 year and a fine not to exceed $4,000. Do you understand that complete range of punishment. See that the plea agreement is that you plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed at 3 days confinement in the county jail. You'll be receiving credit for all 3 days. In addition, you would pay a fine of $3,500 plus court costs of $270 and reimbursement of $90. Is that your understanding of the plea agreement?
Yes, sir.
That's what you're asking the court to approve today? All right, and Mr. White, you believe Mr. Cashion to be competent today?
Yes, I do.
Okay. All right. Mr. Cashion, then, understanding the plea agreement and the range of punishment, how do you plead to the lesser included offense of Class A misdemeanor assault causes bodily injury or pain? Are you pleading guilty to that crime, Mr. Cashion, because you are guilty of that crime for no other reason?
Yes.
All right, has anyone threatened, force, or pressure you to plead guilty to this offense? Courts will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Is there anything further from the state with regards to victim compliance?
Your Honor, the state isn't applying for victim notification. However, we have no documentation to present to the board at this time.
All right, so anything further from the defense, Mr. White? All right, court's going to review the evidence briefly. All right, the court has reviewed the evidence. The court does find sufficient evidence to convict Mr. Cashion of this offense. Court will follow the plea agreement. The court convicts Mr. Cashion of Class A misdemeanor assault causing bodily injury of a family member, assesses his punishment in accordance with the plea agreement at 3 days confinement in the county jail. Court issues him credit for those 3 days time served, orders him to pay a $3,500 fine, $270 court cost, $90 reimbursement fees. Mr. Cashion, how soon can you pay off this money that you owe?
Give them 500 a month.
500 a month. What can you pay today?
I can give you 100.
100 today, and then you can pay another 400 before the end of the month, or when?
Second Wednesday of each month.
All right. So what I'm going to do, Mr. Cashion, is I'm going to order you after you leave today is to go over to the courthouse to the clerk's office and pay that $100 that you can pay. And then I want you to go to the other end of the hall and meet with the court compliance officer, Ms. LaPratt. They can direct you there in the clerk's office. And then you'll need to set up a payment plan. Just tell them you need to make your payment and tell them you need to make a payment plan for the rest. Okay.
Yeah, approach.
Yeah.
I don't think I got this one too.
All right, Mr. Cashion, you're hereby remanded to the custody of the Van Zandt County Sheriff to carry out the terms and conditions of the sentence and have you come forward to be fingerprinted Deputy Everett. After this, you'll get a copy and then you'll be free to go. Just make sure you get to the courthouse before 5 today, okay? Come on up here, officer. Mr. Shoemate, if you're there, I've got one more plea to do and a couple things to do, and then I'm gonna call your time, Mr. Beverly, back up. Key and Jernigan. Keon. Called you Keon earlier. Yeah, I said it's Keon. You said right. And I called you Keon.
It's Keaton and Keaton. I hear it all.
I know, but I want to call it for. There you are. Sorry, no one. I'm getting on that. I thought this was Jeff's client. He was here. I just saw light. I said, hey, it was calling.
Wait, back.
Okay. All right. Mr. Jernigan, you'll raise your right hand. Sir, you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so be that. Yes, sir. All right, you can all you. All right, your name is Keon Devon Jernigan, is that correct? Yes, sir. All right, Mr. Jernigan, are you a United States citizen? Yes, sir. And do you read, write, and speak English? Yes, sir. Have you ever been diagnosed with any type of mental condition? Yes, sir. What have you been diagnosed with? Anxiety, and I got PTSD. Okay, are you currently on medication or undergoing treatment for those? Yes, sir. Okay, do you feel like you have a rational understanding of what's going on in this case today? Yes, sir. In this case, you're also represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you? Yes, sir. Do you feel like you've had enough time to talk with him about your case, have all your legal questions answered? Yes, Your Honor. Is there anything about any of this paperwork that you've read over and signed with him? I do not understand. All right, and Mr. White, do you believe you found to be competent today? Have you explained to him his rights as they pertain to this case?
Your Honor, I believe that Mr. Jernigan is competent, that he understands the proceedings that are given against him today. He's executed some waivers. I believe he's executed those knowing and intelligent regard to.
All right, and Mr. Jernigan, it seems that you were originally indicted with a state jail felony offense of money laundering greater than or equal to $2,500 less than $30,000. However, it looks like the plea agreement in this case is that you would plead guilty to a Class A misdemeanor offense under Section 1244B of that same charge. The plea agreement appears to be that your sentence would be assessed at 2 days in the county jail. You would get credit for that time served. You'd be ordered to pay a $2,000 fine, plus your court costs and reimbursement fees. And it appears that the DA's office would be asking the court to dismiss a couple of possession of marijuana less than 2 ounces. And another indicted money laundering 30,000 or 150,000 in CR 22-184. Is that your understanding of the plea agreement? Yes, sir. And that's your understanding as well, Mr. White?
Yes, sir.
And there's also an agreement in a civil case, SF 22-6, where it appears that there's an agreement with regards to the forfeiture of some United States currency. And Mr. White, you're representing Mr. Jernigan in that matter as well. Is that correct?
I am, Your Honor.
And Mr. Jernigan, that's your agreement in that case. Is that correct? Yes, sir.
Your Honor, and we won, I think the most recent found there's a portion of money that is going to be returned. And then that will also minus the fine and court costs will be paid out of that.
Okay. And I felt on the record, there's also an agreement in SF 22-3. So there's two seizures, one of 11,682 and one of 37,550. It appears that the state and defense have reached an agreement in each one of those causes, as evidenced by the signature of counsel and Mr. Jernigan has responded in each one of those. All right, so Mr. Jernigan, the range of punishment for money laundering $2,500 to $30,000 under 1244B would be a maximum of 365 days in the county jail and a fine not to exceed $4,000. I see here that the plea agreement fits within that range of punishment. So you're understanding the plea agreement and the range of punishment. You still wish to go forward with this plea agreement? Yes, sir. All right, Mr. Jernigan, then how do you plead to the offense of money laundering $2,500 but less than $30,000? Yes. Are you pleading guilty to that crime because you are guilty of committing that crime for no other reason? Yes, sir. All right, Mr. White, or the court will take defendant's plea of guilt. Find that it is he's making that plea intentionally, knowingly, voluntarily. Mr. White, is there any objection to the state's evidence in this case?
No, sir.
Or will admit state's evidence as the stipulation of evidence in State's Exhibit 1, and the court takes judicial notice of Mr. Jernigan's judicial discussion. Is there anything further from the state?
No, Your Honor.
From the defense? Court's gonna review the evidence. All right, of course, reviewed the evidence and we find sufficient evidence to convict Mr. Jernigan of this offense. Court will involve the plea agreement as recommended by the state of Texas. Court hereby convicts Mr. Keon Devon Jernigan of money laundering greater than or equal to $2,500, less than $30,000. Under section 1244B of the Texas Penal Code, that's a class A misdemeanor. Assesses the punishment at 2 days in fine and county jail. Court issues him credit for 2 days. Time served, orders him to pay a $2,000 fine, $270 court costs, $35 reimbursement fees. Court dismisses under section 1245 DA 2022-349 possession of marijuana less than 2, DA 2022-324 possession of marijuana less than 2. And also CR 22-134-184, money laundering greater than 30,000, less than 150,000. All right, Mr. Jernigan. The board has granted the plea agreement that you want, it's on the paperwork. Just a moment, I'm gonna have you step up to the fingerprint with Deputy Everett. I'll also sign the agreements in the civil case of penalty.
I'm 28.
28. What do you want to do with your life?
I've been working for myself like last 8 months. I finally got to where I can do what I want to do. I breed dogs. I got a landscaping. Like I finally got to where I want to be.
Not doing this anymore.
I don't have. I rap too, but
This is a dangerous profession here.
yeah, but rap.
carrying large amounts of cash.
I mean, with that's what they like to see in the videos. They like to see, you know,
People like to see that in the movie. Do you think they're running around with $50,000 on movie set?
nah, they got problem.
To my point,
Yes, sir. But to my credit, one time, like, okay. Yeah, I have to say, I don't even want to go into the.
you got a good lawyer.
I accidentally, well, I had some motion picture money from a video before, and they tried to charge me with counterfeit money until it said motion picture on. And that's the only thing that saved me, so I try not to even use that money.
Saying running around with large amounts of cash makes you a target for robbery, things of that nature. That's dangerous.
I've been shot 6 times.
I know, that's not good. I know they may want to see that in the rap video too, but that's not good. It's not good for you. All right, you get what I'm trying to say?
Yes, sir.
All right, you need to get professional. You can be an old man like me, not a young man.
I pray I see your age now.
Step up here and be fingerprinted. With Deputy Everett. You're an old man. We're old together. Who else? Who else we got? Oh, we got this guy. All right, Shaquille Rogers. All right, Mr. Rogers, if you'll raise your right hand, sir. You swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so be done? Yes, sir. Put your name down. All right, your name is Shaquille, it's Shaquille O'Rogers. Keith.
Thanks for that. That's what it is.
They
They just have a middle.
Oh, is that Pete? What do you want to do on that?
That's how I do it. Because
What we do, Shaquille, O, apostrophe. Rogers, just like that?
we will know if we have no question.
All right, so, Mr. Rogers, are you a United States citizen?
Yes, sir.
You read about speaking English?
Yes, sir.
Ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Nolan. I feel like you had enough time to talk to them about your case and have all your legal questions answered.
Yes, sir.
Anything about the paperwork that you've read and signed today that you don't understand?
No, sir.
So why do you believe that you're confident in how you're still doing his rights as it pertains to this case?
Mr. Rogers is competent and understands the proceedings that are pending against him here today, that he's execute his rights knowing and intelligently and voluntarily execute the waivers. If the court goes along with plea agreement, he'll be placed on the further adjudication. And note to the court that I've gone over with Mr. Rogers' advantages and disadvantages of such a plea agreement. Most notably, he violates the term of condition of the probation. And that is shown at a hearing, the court can revoke his probation finding guilty and it's even for the punishment range, which is 180 days. And a fine up to 60,000.
You understand all that, Mr. Rogers?
Yes, sir.
All right, Mr. Rogers, Mr. White has aptly stated the range of punishment for this charge, which you've been indicted for, which is possession of controlled substance. Felony group 1 less than 1 gram of state jail felony is a minimum of 6 months to a maximum of 2 years and a fine up to $10,000. You understand the range of punishment, you understand the plea agreement, you still wish to go forward?
Yes, sir.
All right, Mr. Rogers, then how do you plead to possession of controlled substance? Felony group 1 less than 1 gram.
Plead guilty.
We plead guilty to that crime because you are guilty of committing that crime for no other reason.
Yes, sir.
Anyone threatened force or pressure to you to plead guilty today? No, sir. Court will accept the defendant's plea of guilt. Mr. White, in objection to the state's evidence.
Objection.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
From the defense? Everyone's briefed. want to see a lab report in here. Do you stipulate as to what that it is a controlled substance in the amount?
Yes, sir, it was cocaine.
And you saw a quantitative amount, several.
I believe that it was not that shape, just not sure about. I'm gonna do a field test now.
Total has 0.31 grams.
Point. All right, court finds that based on the evidence, there is sufficient evidence to convict Mr. Rogers of this offense. Court will follow the plea agreement. Court will defer finding of guilt, and place Mr. Rogers on 2 years community supervision, order him to pay a $1,500 fine, $180 restitution. Court will dismiss under section 1245 an unlawful carrying of a weapon and a possession of marijuana less than 2 ounces. Court orders court costs to be paid in the amount of $290, reimbursement fees of $35, and a restitution of $180. Mr. Rogers, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so we can carry out terms and conditions of the claims. And then you step up here to Deputy Evers is being appointed. After this, the probation officer will give you further information. Santana Martinez. Ms. Martinez, this is CR 2232. Go raise your right hand, ma'am. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So if you're going to, you want to use say your stuff on that table. Ms. Martinez, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? You're represented by Mr. White. Do you have any concerns about representation? Are you pleased with what he's done for you? Do you have any questions for him? Anything about this paperwork that you've read? You don't understand. And Ms. Martinez, it appears that you were originally indicted with a second-degree felony offense of aggravated assault with a deadly weapon. However, the plea agreement before the court is that you would be pleading guilty to a lesser included offense of a Class A misdemeanor assault causing bodily injury. A family member with a plea, a recommendation that is 2 years deferred community supervision, $2,500 fine, plus court costs and reimbursement fees. Is that your understanding of the plea agreement? Mr. White, do you believe Ms. Martinez to be competent today? And if so, have you explained to her the consequences of her plea to a deferred adjudication?
Your Honor, I believe she confident that she understands the proceedings of opinion. I believe that she's waived her right. And I've explained to her the ranges of disadvantage of deferred adjudication. In this case, should be pleaded to a Class A misdemeanor, which means it's violates any term or condition. Court so finds. After a hearing, the court can adjudicate her guilty, revoke her probation, and at that point, sentence her up to 1 year in county jail, not to exceed $4,000.
Right. You understand all of those things? Ms. Martinez? All right, understanding the plea agreement and the allegations, Ms. Martinez had to plead to lesser included Class A misdemeanor offense of assault causing bodily injury to family members. You're pleading guilty to that crime because you are guilty of committing that crime. Has anyone threatened, force, or pressure you to plead guilty? All right, court will accept the defendant's plea of guilt. Mr. White, any objection to the state's evidence?
No objection.
State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Looking further in the state.
No, Your Honor, sorry, Judge, yes, the state is in compliance with victim notification, but other than that, there's nothing to reference.
And any response on victim notification supportive of this plea, not supportive?
Your Honor, no response to victim notification at all.
Thank you. Person review the evidence. Court reviewed the evidence, finds that there is sufficient evidence to convict Ms. Martinez of this offense. The court will follow the plea agreement and the recommendation of the state. Court hereby defer the finding of guilt of assault causes bodily injury, family member, class A misdemeanor, places Ms. Martinez on 2 years community supervision, orders her to pay a $2,500 fine, $270 court costs, $35 reimbursement fees. Ms. Martinez is remanded to the custody of the Community Supervision and Corrections Department, so they can carry out the terms and conditions of this. I've set forward to be attended with the FDA. Daniel Worley. CR 22-120. Worley, your raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Worley, same questions I've asked everyone else. Are you a United States citizen? Yes. Do you read last opinion?
Yeah.
Have you ever been diagnosed with a mental condition? Have you played with Mr. White as your attorney? Well, you guys have time to talk with him about this case and have all your legal questions answered. Mr. White, you believe Mr. Worley to be competent today?
You're all right, but he understands the procedure. We've executed some waivers. He's done so.
Mr. Worley, it appears that you were originally indicted with a third-degree felony offense of cruelty to non-livestock. However, it looks like the plea agreement today is that you would plead guilty to the lesser included offense of cruelty to non-livestock animal or class A misdemeanor with punishment of 1 day in the county jail with credit for time served, with you paying a maximum fine of $4,000 plus court costs of $270. You'd be given credit for your 1 day in jail. Was that your understanding of the plea agreement? Yes. That's what you're asking the court to approve today. The range of punishment for a class A misdemeanor is a maximum of 365 days in the county jail and a fine not to exceed $4,000. The court will find that this plea agreement would fall within that penalty or that punishment. Understanding those things, Mr. Worley, how do you plead to cruelty to non-livestock animal class A misdemeanor?
Good.
You pleading guilty to that crime, Mr. Worley, because you are guilty of that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this? The court will accept the defendant's plea of guilt. Mr. White, in objection, state's evidence. So state's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor.
It was your victim. Was any victim notification required in this case?
No, Your Honor.
Court's going to review the evidence. Court reviewed the evidence. Court does find sufficient evidence to convict Mr. Worley. The court will follow the plea agreement in this case. The court hereby convicts Mr. Worley of class A misdemeanor cruelty to non-livestock animal, sentences punishment at 1 day confinement in the county jail with receiving credit for 1 day served. Court orders him to pay a $4,000 fine and $90 reimbursement fees and $270 court costs. Court hereby remands you to the custody of the Van Zandt County Community Supervision and Corrections Department so we can carry out the terms and conditions of the sentence. Mr. Worley, I have you step forward. You can return it. And when are you paying these things, Mr. Worley?
I'm still good. Get with them over there.
Yeah, but when are you gonna pay them?
I'm gonna pay whatever they tell me to pay a monthly basis.
How much can you pay today?
Nothing today.
Nothing today. How much you be able to pay on a monthly basis?
I'm hoping to be the over.
All right, well, I want you to go over and set up that payment plan today.
Yes.
Which I told him to talk to you about this. I'm not this afternoon. He's got a new indicted case that I have not been retained on. It's got other unindicted that I have not been retained on. I'm apologize to you on this, but I forgot to put the titles yesterday. I got to think about something. What I'd like to do is I'm gonna call them. I need to call them. I need to find out what's going to be required of me to rectify everything, because it's going to be at least maybe two parties involved, making that right. I'm on the shop, but I'll get on. And then I'll let you know. But I'm sorry, because we said that, we did arraign last time. Because I hadn't been retained on it, I didn't have everything. But I got to thinking after I talked to Kyle yesterday, some job check.
Okay, we're better now. We better find out now. I say, Judge, I'm ready for trial.
Mr. Chadwick. Mr. Beavers is going to law. Miss Curry and he's things plans that he's going to have the court to reconsider his previous decision to place him on trial docket to allow him to leave. We also can't turn today, but we're supportive with asking the event of the region. You might do it in
Billy Frank Jennings. All right, this is cause number CR 2227. Mr. Jennings, if you'll raise your right hand. Mr. Jennings, do you swear that the testimony you give before will be the truth, the whole truth, and nothing but the truth, so help you God? Yes, sir. Thank you, so you can lower your hand. Mr. Jennings, I see that you filled out some paperwork stated with Mr. White, wherein you want to enter into the court's pretrial intervention program. Is that right? Yes, sir. And you've taken time and you've read over this paperwork and you've signed several pieces of it. Do you understand everything that you've read and signed today? Yes. Mr. White's been assisting you throughout this process. Are you pleased with his representation of you? Yes, sir. Do you understand that if the court places you in this program, you'll be stipulating to some evidence, the admissibility of that evidence if you ever go to trial? You understand that? Yes, sir. You also understand that you'll be waiving your right to a jury trial in this case. Yes, sir. And so you understand that as you stand there right now, you enjoy the constitutional right of a jury of your peers to decide your case, to decide whether you're guilty or not guilty. You understand that? And you understand that you can tell this court, you know, Judge, I pled not guilty. I want a trial, and I can go and bring in a jury of your peers and Mr. White and Ms. Pfizer for the state. We can all go through this jury selection process, and that jury can be impaneled to hear your case. And you understand that you also have the right to waive that process, right? You understand? And that's what you're wanting to do in order to enter into this program today. Is that right? And you understand that once you waive your right to a jury trial, that right may not be restored to you. You understand that? That means if you have buyer's remorse later, then you can't come back and say, Judge, now I want that jury trial. You understand that? Yes, sir. Okay. And has anyone threatened, forced, or pressured you to make you feel like you had to waive your right to a jury trial? Has anyone threatened, forced, or pressured you to make you feel like you had to waive your right to the speedy trial? Or waive your right to expunction of the VA records or the probation office records? Has anyone threatened or forced or pressured you to do those things? And you understand that if I approve this, you're gonna be placed in this program for up to 1 year on the offense of evading arrest or detention with a vehicle. Is that right?
Yes, sir.
All right, and Mr. White, do you believe that Ms. Jennings is competent today and can enter into this agreement? And you've explained to him his rights pertaining to this pretrial intervention contract and what he would be waiving in the stipulation regarding the disability of the evidence and those things should he go to trial.
I told him that this be in front of the court would know that this was a failed PTI. A lot of times it's hard to get another child in probation.
You understand that, Mr. Jennings?
Yes, sir.
Okay, understanding all of those things, you want the court to approve this agreement and place you in this program, is that right?
Yes, sir.
Okay. All right, the court will find that Mr. Jennings has been admonished as to his right to a speedy trial, for his function of records, and to a jury trial, and he has waived all of those things intentionally, knowingly, and voluntarily, the waiver of his function with a limited waiver. Or will approve his placement in the program for up to 1 year for the offense of evading arrest or detention with a vehicle. Court also finds the state is waiving its right to a jury trial in this case. And that Mr. Jennings' waiver of jury trial has been joined by his counsel, Mr. Jeff. All right, Mr. Jennings, the court has approved your placement in that program, so I'm gonna have you step over here with Officer Burns, and she'll give you more information about the next step, okay? Thank you. You're welcome. Mr. Shoemate, are you ready?
Yes, Your Honor,
There you are, yeah.
I'm here.
Come on up, Mr. Beverly. Yeah, I appreciate your patience. I tried to get you in earlier, but caught you at a time you were away, and so I just kind of moved on. But Mr. Beverly is
It's-
here.
Thank you, Your Honor. We're here.
All right, this is cause number CR 2160, State versus Nicholas Shane Beverly. We're set for pretrial today. Mr. Shoemate, have you received discovery? Are there any issues with discovery?
There are none, Your Honor. We have received the discovery. We've had a chance to review it, although I need to review it with my client a little more, but we have got it.
Okay, do you anticipate any contested pretrial motions?
I do not.
Okay, so what I'll do, my practice, Mr. Shoemate, is to set then the case for docket call. That allows you time to continue going over the discovery with your client and talking about any possible trial strategies and or plea negotiations with the state. So the next setting, what I would anticipate is for all those things to be concluded and for Mr. Beverly to be able to tell me if he wants to enter into a plea agreement or ask for a bench trial or a jury trial. And so if you have your calendar available, I want us to work together on picking out a time that works well for you in the court. Okay, so I would look, what about October 11th, 13th, or 25th?
Your Honor, what day of the week is the 25th?
That is a Tuesday.
That would be fine.
Okay, so what I'm gonna do is we're gonna fill out a notice of setting for Mr. Beverly, have him sign that. We're gonna put that date on there. And that will be October 25th. That will be at 9 a.m. And I believe on that day, we'll be back in Canton over in another courtroom. We'll send notice to counsel and bonds where we're gonna be hosting for that day, okay?
Yes, Your Honor. Thank you.
The
same one we were at last time.
I don't remember where we were last, it's a small one over there behind the,
It ain't the big.
no, it's not okay. No, we're out of the big one for a little while. No, this would be a smaller one, just north of the courthouse in another county.
Yes, sir. Thank you.
Have you signed right here, Mr. Beverly? All right, we're gonna give him a notice, Mr. Shoemate, and he is free to go. I appreciate you, sir. Your excuse.
Thank you, Your Honor, for your indulgences. Have a good day.
Beautiful. Thank you. Yeah, you're welcome. Thank you for your patience.
Do a step on this, Mr. White, mine, if you would, just.
Keep going. Yeah, I missed this one. With, all right, Mr. Bryce. So, I'm saying Mr. Bryce, it's Mr. Carroll, right? It's right, Carroll, sorry, good. It's always a problem. All right, so. Let's see here. Oh, did she take a break? She went on it, didn't she? All right, and was the UA on Mr. Carroll thing? Oh, that was, okay, that was that one. Okay. All right, so. So what I'm doing to you is trying to keep you on the right track, you understand that? I'm trying to keep you out of prison. Okay, so what I'm about to lay out for you today is something that you can accept or reject. But a rejection may have consequences that, or something you may not want. Understand? Okay. So you're on probation. You know you can't be smoking weed. Right? Okay. You know what you're responsible for doing. So you know, we've already talked about this a little bit. You know kind of what's hanging over your head. You do, right? You know you got a significant prison sentence hanging over your head. Right? Right? Okay. Well, tell me if I'm saying anything you don't understand, I want you to tell me. Okay. Purpose of sanctions court is when you have violations that are not significant or overwhelming. That where we try to sanction you to get your attention, to not do those things so that you don't get a motion revoked, so you don't get in the court system, so you don't get revoked, get convicted, sent to prison. How old are you? 21. You are a young man. This is a sanction court hearing. You are a young man. What do you want to do with it? Do you know what you want to do yet? And that's okay if you don't. You're a young man. I have a 21-year-old. He's figuring it out too. It's okay if you're figuring it out. You're going to shut down those options. You're going to shut down those opportunities if you get convicted as a felon. You're going to shut those down even more if you go to prison. And going to prison for smoking weed, not doing your community service, not paying, not doing those things. That doesn't make any sense. That is not smart. That you're going to materially and substantially affect your life. Substantially. Convicted felons have a very hard time getting a job. You can go out here and you can ask a lot of the men and women that are in this room what their life is like. They're going to tell you it's not good because they can't work, can't make money, can't support themselves, and they find themselves in the same circle. That's what I'm trying to prevent you from being there. I don't know if you want to do that. I don't know if you want to avoid that, or if you don't. I don't know if you need someone to get your attention. That's what I'm trying to do. I'm not going to sit here and yell and scream and holler at you because it's not effective. All I can do is be real with you. Okay. And the reality is this: if you don't treat this like a job, if you don't treat it like a job and do everything that you're supposed to do above and beyond, then you're going to find yourself sitting in a prison cell wondering why you screwed your life up. There's going to be no way out of it. Okay? This is what I need you to do. All right. you're gonna have to pay, you gotta get current on your fees, you're gonna have to pay into your probation. All right, you're gonna have to pay your court collections. You gotta do 10 hours community service every month nonstop. Okay, you gotta stay, you can't wait till the end and try to knock out 300 hours. It just doesn't work. Okay, you would run out of time. You've got to do your substance abuse evaluation. Okay. So I've got to give you a sanction for testing pot for marijuana, for using marijuana, for admitted, you admitted, right? Okay. So that I commend you for doing that. You've got to have a consequence for that. Okay. So what I'm going to do is I'm going to sanction you 4 days jail. 4 days. You got to do jail 4 days. I'm going to let you pick the 4 days that you want to do. Okay. You have a job yet? When's your job?
Monday through Friday. It's a 12-hour shift. We just started that this week, so I'm not sure. We do like 4-day week, 3-day week.
Well, so what I do is I will let you split that up into two days and 2 days. Okay? That way it doesn't affect your job. Because I don't want you to lose your job. Because your job is going to help you pay these things and help get you in the right track. Okay? So you can say, Judge, yeah, I'll accept those sanctions. I'll do those things. I'll get back on the right track. Or you can say, Judge, I don't want to do that. And I'll let the probation office know and they can make their decision on whether they want to file a motion to revoke or not. So what do you think?
All right, so
You accept? Okay, so I'm gonna let you do 2 days, 1 and 4. He's gonna do 2 and 2. I'm gonna let him pick those days. He's got a job. He's gonna work around that. So what I'm gonna do is you're gonna go meet with Officer Burns and we're gonna figure out those dates. He's gonna give me the order I'm gonna sign. You're gonna take that order. We're gonna show up at the Bandit County Jail on those days with your ID. You're gonna serve those 2 days. You're gonna get out. You're gonna go back to work and do what you're supposed to do your community service. Then you're gonna go do your next 2 days, right? You're gonna pay $85 each month to probation. You got this job, all right? $85 has to go to probation.
what's the 90?
$85 for probation, $85 to your court collections, because you receive fines, court costs, all these things. Those are the amounts that you have to pay in order to stay current, so that you can get off probation when you're supposed to be off. You got on in just last year in December, you got 6 years. That's what you have to do to stay on track to be off in 2027. Which is a long way away. If you start doing well, you get ahead of the game, you start paying things off early, you might be able to get off probation. But if you don't pay these minimum amounts, you'll never get caught up in time to get off in time. Okay, and then you'll get extended, you'll get pushed out, and then you'll have me in your life for longer than you want me in your life. Okay, all right, you understand what I'm saying? Okay, all right, I want you and I to be on the same page here. You seem like a smart kid. That's kind of, unfortunately, you're still a kid, you're still learning, right? So I want to see you have opportunities. I want to see you have options. And this is what I have to do to get you there, right? So don't look at this as a punishment. Look at this as a blessing. That you're not getting locked up today. You'll have a motion to vote. You're not looking at her as a state prosecutor asking, hey, he didn't do his probation condition, send him to prison, judge. Okay, and she's going to be doing that later today on some other people. Okay, so you can look at it negatively, you can look at it positively. Okay, so can you do those things? All right, so and you've got to put forth the effort. You've got to stay in contact with your probation officer. Okay, get them on your side. You understand? Okay, once you start doing well at this stuff, I won't make you come back here to court. I'm going to keep my thumb on you for a little bit. Once you show me that you're accepting this and you're being serious about this responsibility, then I'll let you out of sanctions court and you go back to doing regular probation and report. Where do you report, here or somewhere? Waxahachie. Do you live up there? Okay, you do what you're supposed to do for me, and then I will let you go back up there and I'll leave you alone for a little while. As long as you can show me that you're on the right track. Okay, all right, to go with Officer Burns, she's gonna get those days worked out for you, and then she'll give you the paperwork. Let's see, I'm gonna come back. Let's go. So November. When do you work? You work here? You do 4 days, 3 days?
I can come everyone.
Early in the morning?
I gotta do it 5.
So as long as you're at 9 o'clock, sometimes you're okay. All right, so let's do, do 4 day, 3 days, so some Thursdays are off.
I'm not trying to ask my supervisor, I just started past Wednesdays.
Let's put it on Thursday the 10th, maybe that'll hit one of the 3 day weeks or whatever. Is this your dad out here?
On Saturday.
Your stepdad? Okay. You here to support him? Is
Yes, sir.
there anything that I said that you disagree with?
No, you did it on the button. All keys.
You ever hear any of that from him? So do you think he's being mean and being hard on you, or what do you think?
No.
What's he doing?
Everything was right.
Yeah, that's exactly what's right. What's wrong? He loves you, obviously, or he wouldn't be here. Okay. Then it's the one.
Yeah.
And you get, well, I should say it doesn't get. You need anything else, Mr. Carroll? We need that order, the minute order, right? Go ahead, Paul.
Thank you, Lord.
You're welcome, sir. All right, so we're still doing your name now?
Sure.
Okay. Yeah, okay, you have a, okay, all right, Miss Simpson, come on up. This is CR 2225. Ms. Simpson, the court has reviewed your application for court-appointed attorney. The court finds you to be indigent at this time. The court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning is not in court today, so what I'm going to do is I'm going to reset your case. And I believe that Ms. Abraham has given you the contact information from Mr. Manning. So you'll need to be in contact with him. We'll send over a notification that he's been appointed to your case. So maybe a day or two before he knows who you are. Okay, so we'll get mad at him if you call him. He doesn't know who you are, right? So what I'm going to do is I'm going to reset you for today is the 20th. I'm going to put you on the contested docket for October 27th. Okay, so October 27th, I'm going to have I'm doing sign this notice of appearance right here. We'll notify Mr. Manning, and then we'll come back on the October 27th. Maybe you'll have a deal worked out. If not, then we'll have a hearing. State motion. Then I'm gonna do a sound we get the ever. It's just a reset notice, and you're coming back on that date at that time. Okay.
So we'll just, I mean, I don't have to know that.
Any questions? All right, and before you leave, Ms. Swanson, oh, motion or votes. Okay, so you're still on probation. Okay, so you'll never report. You gotta call and just say they file a motion, doesn't mean you don't have to follow all this. Okay, so stay in contact with probation. Yes. Thank you. All right, court has completed its morning docket. We'll stand in recess until 2 o'clock. 2 o'clock. We'll resume. Same time, same channel. Hit that subscribe button.